Hello, my name is Amber Holloway, and welcome to the September 2021 episode of my PIP Monthly. Our September 2021 topics include, of course, a case law update. We'll be talking first about the case of Adam C. Humphrey v. Homeowners Insurance Company, which was issued by the Court of Appeals on August 19th, 2021. Then we'll be talking about the Blanca Sierra Burks v. Troy Aggregate Carriers Insurance Company case, which was issued on August 12, 2021. Both cases are unpublished opinions by the Michigan Court of Appeals. And then moving on to trending topics in PIP litigation, we will discuss no-fault tolling during the pandemic and the governor's orders extending the tolling period. All right, first up is the case of Adam C. Humphrey v. Homeowners Insurance Company. This case is further narrowing of the Bari decision. It essentially reduces Bari to being redundant of the Bazzi case and makes it even harder for insurers to file the fraud motions for summary disposition. Here, plaintiff argued that the trial court erred on the basis of a common law fraud argument because under Hayda v. Farm Bureau Insurance Company, false statements made by the insured during litigation are incapable of satisfying the elements for voiding a policy on the basis of post-loss fraud. I believe we previously talked about the Hayda v. Farm Bureau opinion, which also narrowed Bari and Bazzi. Here, the trial court granted Homeowners Insurance Company's motion for summary disposition after it was determined that there was no genuine issue of material fact as to whether plaintiff's claim was barred by common law fraud. The court determined that Humphrey's statement made during her deposition were material misrepresentations, that the statements were false, and that she made the statements knowingly or recklessly and with the intent that the insurer rely upon them. I'm going to give a brief background into the facts. But Humphrey was driving her mother's vehicle when she was involved in a car accident. She then filed a claim for PIP benefits under her mother's no-fault policy, which was issued by homeowners. Homeowners paid some benefits, but then requested that plaintiff go for an IME to assess the need for ongoing treatment. And thereafter, Humphrey filed a claim against homeowners for PIP benefits. She submitted to the IME, and then homeowner sent her a letter stating that it concluded that her claimed injuries were considered to be pre-existing conditions and that no additional no-fault benefits will be paid. Plaintiff's deposition was taken sometime in August 2019. And relevant to the issues here, after the deposition, homeowners moved for summary disposition, arguing that plaintiff made multiple false statements at her deposition. She testified that she suffered from depression, anxiety, headaches, pain in her back, neck, left shoulder, and left wrist. She unequivocally denied that she had any of these issues before the accident. Her medical records directly contradicted any of her denials or all of her denials. Just a quick example, she treated for back pain and anxiety in 2012 and 2015. She also treated for headaches back then as well. She also testified that she had been in a prior motor vehicle crash, but denied the filing of a claim related to that crash. Then records from Allstate showed differently that Allstate made payments to her medical providers as a result of that crash. In that instance, she claimed a head injury resulting from that prior motor vehicle accident. Also, she testified that due to the subject accident, she could not drive for long periods of time due to anxiety and back pain resulting from the impact. But records from Soaring Eagle Casino show that plaintiff visited 76 times in 2018, 110 times in 2019, and 31 times as of March 14, 2020. Soaring Eagle, for reference, is about a 50-minute drive from the plaintiff's home. After oral argument, the trial court granted homeowners' motion for summary disposition. Homeowners essentially argued that plaintiff engaged in actionable fraud or fraudulent misrepresentation. One, that she made material misrepresentations, that they were false, that when the insured made the statements, she knew that they were false or made them recklessly without any knowledge of their truth or positive assertion, that she made these statements with the intention that they should be acted upon by the insurer, and that the insurer actually did rely upon those statements, and that by acting in reliance of those statements, those material misrepresentations, the insurer suffered injury. The Court of Appeals relied on the decision in the Haydaw case. Specifically, the court in Haydaw held that statements made during litigation are by their nature incapable of satisfying elements for voiding a policy on the basis of post-loss fraud. The court said that in order to obtain relief, the material misrepresentation must have been made with the intent that the insurer act upon it. Yet, insured statements made during discovery are made with the intention that the trier of fact, not the insurer, act upon them. To the extent that the insurer acts upon those statements during the course of discovery, it is through their counsel for purposes of litigation strategy and not for the purpose of adjusting a claim. The court also discussed that the Haydaw opinion did involve a fraud exclusion clause in the policy, as opposed to the case we're talking about now, involving common law fraud defense. The basic principle that statements made during the litigation are not made with the intent that the insurer rely upon them, but that the trier of fact rely upon them, applies equally in both fraud-based defenses. So essentially, as according to Haydaw and further as to Humphrey v. Homeowners, so as read in conjunction with Haydaw and the new Humphrey case, fraud must have occurred before the legal proceedings in order for a defendant to be successful with motions for summary disposition. So here we are in the case of Humphrey. She made all these false statements during her deposition testimony. Records showed that she made false statements. Her IME showed that she made false statements as well. It did not warrant a grant of summary disposition, and rather her claim must be tested by the trier of fact. Next up, we have the case of Blanca Sierra Burks v. Troy Aggregate Carriers, Inc. This unpublished opinion was issued on August 12, 2021. Here, a plaintiff appealed the trial court's order granting a McCormick motion for summary disposition in favor of defendant. The Court of Appeals actually affirmed the trial court's order. These McCormick MSDs are becoming increasingly difficult to win. A granting of a McCormick motion for summary disposition in favor of defendant is becoming increasingly rare. By way of quick background, here the plaintiff was driving on I-96 when she discovered that her windshield had been chipped by a rock that had fallen from a truck that she was behind. She attempted to wave the truck driver down. When he did so, she parked her car, exited, approached the truck driver, and requested that he pay for the damaged windshield. The driver refused, stating that his employer would not pay for the damage from road debris. According to the plaintiff, the driver then got back into his truck, pulled forward in front of plaintiff's car, and hit her with the side of the truck or bumper, causing her to fall. She called 911 and was transported by ambulance to a hospital. A medical examination of the plaintiff at the hospital revealed no evidence of injury, and the plaintiff was observed walking without assistance. No criminal charges were filed against the driver of the truck, which was owned by Troy Aggregate Carriers. Plaintiff thereafter filed suit under the No Fault Act, arguing that the alleged incident had seriously injured her, exacerbated her existing injuries, and that defendant, the owner of the truck that had struck plaintiff, was liable for her injuries. Defendant moved for summary disposition, arguing that plaintiff was unable to make the required showing that under the No Fault Act, the incident had caused an objectively manifested injury resulting in serious impairment of an important bodily function, affecting her ability to lead her normal life. The trial court granted defendant's motion for summary disposition, finding that plaintiff had failed to present any evidence that the impairments to her cervical spine were related to the incident at issue. Ultimately, MCL 500-3135, Section 5, defines a serious impairment of important bodily function as an objectively manifested impairment of a body function that affects the person's general ability to lead his or her normal life. In other words, it's an impairment that is evidenced by actual symptoms or conditions that someone other than the injured person observed. Here, whether a plaintiff or person has suffered a serious impairment of a body function or permanent serious disfigurement are questions of law for the court if the court finds that there is no factual dispute concerning the nature and extent of the person's injuries, or if there is a factual dispute concerning the nature and extent of a person's injuries that is not material to the determination of whether a person suffered a serious impairment or serious disfigurement. Again, the impairment must be evidenced by actual symptoms or conditions that someone else other than the injured person has perceived or observed. To find this, we typically look towards ER records, x-rays, statements by plaintiff, and before and after comparisons. Here, the plaintiff went on to argue that the incident exacerbated her chronic neck pain, which resulted in a surgery. But the court went on to state that it's not clear that plaintiff suffered any impairment whatsoever. It was difficult for the court to find an impairment that was evidenced by actual symptoms or conditions by someone other than the plaintiff. Here, the emergency room staff found no obvious injury/swelling or trauma as evidenced by the record. X-rays of her right leg and hip showed no fracture or dislocation, and the staff at the emergency room determined and put in the records that there was no visible evidence of injury. Plaintiff went on to make several contradictory statements regarding the basic facts of the accident as well. She alleged that the impact she received by the truck and her subsequent fall or loss of balance, she represented to a treating physician that she had fallen and caught herself with her outstretched hand. But then she informed the hospital on the day of that she did not fall or lose her balance. Additionally, her argument on appeal focused on her neck pain, but her complaint when arriving to the hospital the day of the incident was that her right leg was in pain. She made no statements regarding her neck pain. However, the plaintiff attempted to rely upon the neck pain. Then the court looked to the before and after comparisons of her medical history, which also provided evidence that she did not suffer an objectively manifested impairment related to the accident. She had a chronic history, long history of pain and mental illness. Before the incident, she described her back and leg pain as constant. She also experienced chronic neck pain that had been bothering her for at least 6 months before the accident. After the accident, she had several episodes of depression, bouts of depression. She continued to experience back and neck pain. X-rays at the emergency room department showed no fractures, and that her own physician concluded that there were no MRIs findings that could strongly correlate with the symptoms that she was having as a result of the incident. In short, because her significant impairments existed before the accident were so similar to the impairments she experienced after the accident, it's not clear that the accident itself caused any of those impairments or any exacerbation of the existing impairments. Plaintiff also argued that the incident caused her to undergo cervical spine surgery. She highlighted a report by her doctor that indicated that her neck was a traumatic cervical disc herniation with radiculopathy after a motor vehicle accident. The court went on to note that the statement made by the doctor in this medical record was not accompanied by any explanation or data and did not suffice to establish a causal connection without other corroborating evidence. Plaintiff did go on to have an IME by Dr. Stephen Calcanus, and Dr. Calcanus actually noted that it was not clear that any acute injury was suffered by plaintiff. He went on to indicate that her cervical spine surgery was both indicated and appropriate, but it was due to the chronic neck complaints and degenerative changes and not the subject accident. Ultimately, plaintiff's chronic long-term pain combined with a lack of physical evidence of an injury that was caused by the motor vehicle accident, led to the conclusion that she did not suffer an objectively manifested injury or exacerbation as a result of the accident. Again, it must be an impairment that is evidenced by actual symptoms or conditions by someone other than the plaintiff herself. And last but not least, I wanted to talk about no-fault tolling during the pandemic for our trending topic in PIP litigation. Prior to June of 2019, MCL 53145 indicated that an action of recovery for PIP benefits payable for accidental bodily injury may not be commenced more than 1 year after the date of the accident unless written notice of the injury had been given to the insurer within 1 year of the accident, or unless the insurer had previously made a payment for PIP benefits for the injury. If the notice had been given or payment had been made, the action may be commenced at any time within 1 year after the most recent allowable expense had been incurred. However, the claimant may not recover benefits for any portion of the loss incurred more than 1 year before the date on which the action was commenced. This is long-standing law, but the Michigan Supreme Court, in the case of the Developers v. Auto Club Insurance Association, it noted that the two limitations on the time for commencing an action, and that there was one limitation on the period for which benefits may be recovered. So, 1 and 2, an action for PIP benefits must be commenced no later than 1 year after the date of the accident, unless the insurer gives written notice. And 2, if the notice has been given or payment has been made, the action may be commenced at any time within 1 year. But recovery is still limited to losses incurred during 1 year preceding the commencement of the action. And then we have no-fault reform. MCL 53145, as we all know, was amended in June of 2019. And that amendment included the following: an action for PIP benefits payable for bodily injury may not be commenced later than 1 year after the date of the accident, unless written notice of an injury had been given to the insurer within 1 year, or the insurer has made a previous payment of PIP benefits. 2, Section 2, subject to Section 3, if the notice has been given or payment has been made, the action may be commenced at any time within 1 year after the loss has occurred. However, the claimant may not recover benefits for more than 1 year on the date of which the action was commenced. But no-fault reform added this Section 3, so a period of limitations applicable under subsection 2 to the commencement of an action and the recovery of the benefits is told from the date of a specific claim for payments of the benefits until the date an insurer formally denies the claim. This does not apply if the person claiming the benefits fails to pursue the claim within reasonable diligence. So here we have the issue: the insurer must formally deny the claim, or the statute of limitations is told. But even if the claim is not denied, the person filing the claim for benefits must do so within reasonable diligence. So what does the term reasonable diligence, what is that defined as, is going to be the issue. Then in March of 2020, the world shut down and the pandemic began, and then the Michigan Supreme Court issued the Administrative Order 2020-3, AO 2020-3. This order told the statute of limitations to file a pleading due to the pandemic. It excluded any days that fell during the state of emergency and computing deadlines in which a claimant may file suit. So you just take those days off while we were in the state of emergency. This was recently rescinded with AO 2020-18. As we talked about earlier, MCL 53145 contains both a statute of limitations and a limitations on computing damages. This was specifically talked about in the case of Joseph v. Auto Club Insurance Association. And Joseph is the current law of the land. It's pretty much what these issues are decided upon. In Joseph, the courts specifically note that MCL 500-3114, Section 2 contains the two limitations. But Joseph also states that the second limitation, also known as the 1-year back rule, sets limitations on the amount of damages a claimant may request. So here we have an issue where a plaintiff will argue that the Michigan Supreme Court administrative order permits a party to not only toll the statute of limitations to file suit past the 1-year back, but it also allows the party to recover benefits for any portion of the loss that incurred in that time period as well. The statute does not specifically state that a plaintiff will be able to recover benefits. So due to that failure to explicitly state the ability to recover benefits, plaintiffs should not prevail pursuant to Joseph. So Joseph survives the statute because, unlike any administrative orders, it looks to the clear language of the statute, which explicitly states that a claimant may not recover benefits for any portion of the loss that incurred 1 year before the date on which the action was commenced. So while plaintiff may still file their complaint, those damages still need to be taken out. Again, a claimant cannot recover for any portion of the benefits incurred more than 1 year before the action was filed, even in the case of tolling due to the pandemic or due to the state of emergency. And that is all I have for the September 2021 episode of my PIP Monthly. Again, my name is Amber Rouse Holloway, and I'm a partner here at our Troy office. I look forward to any questions or concerns you may have, and please feel free to contact me. Thank you.